for bond? Okay, be seated, please. It's Mandy Nisley. All right, case number 23 CR 140. Dave Joe Nisley appearing there from the jail.
Yes, sir.
All right, Mr. Man Nisley, you were charged and convicted originally in this case for breaking and entering 2 counts, 5th-degree felonies from placed on community control back on November 8 of 2023. Now, there's been a notification filed by Officer Parr and alleged that you have violated the conditions of that original entry plus the additional entry, I believe, admitting you to drug court on March 26, 2024. Mr. Parr is present for this hearing being conducted by Zoom, the defendant's appearing from the jail. And Mr. Parr was the victim of the offense. Victim or victims notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, I will.
Thank you. All right. So, Ms. Nisley, the 2 offenses of which you were convicted carry a possible term of incarceration of 12 months each. So it could be a total of 24 months. You do have the right to have a hearing on these allegations in which the state would have to produce evidence that proves that you have committed the violations that are alleged. You do have the right to have an attorney to represent you in the matter, and if you don't have the money to hire one, the court will appoint one for you. I see you did fill out a financial disclosure form. Is everything on this form correct?
Yes, sir.
All right. So you're requesting that you have an attorney represent you in this hearing?
No, sir.
Pardon me?
No, sir.
Oh, you're not requesting to have an attorney appointed?
No.
All right. Well, if you are convicted or if you're found to have violated these conditions, like I said, then you could be sentenced to a term of 24 months of incarceration. You could also be fined $2,500 in each count for a total of $5,000. Now, you do have the right to have an attorney, and the court will appoint one for you, as I indicated, if you do not have the money to hire one. You understand that?
Yes, sir.
And if you don't have an attorney, then that means you're going to be responsible for advocating on your own behalf and making your own decisions without benefit of counsel regarding the allegations of this matter. You understand that? All right. And you understand the possible consequences if you're found to have violated the conditions.
Yes, sir.
All right. And has anyone promised you anything or threatened you in any way to get you to admit to to get you to waive your right to an attorney?
No, sir.
And has anyone promised you anything to get you to waive your right to have counsel?
No, sir.
So you've not been promised that if you're found to have violated these conditions that any particular disposition will be made?
No, sir.
All right. Now, you have any questions then about your right to counsel?
No, sir.
Okay. So you're voluntarily going to give that up?
Yes, sir.
All right. Well, the officer, Sergeant Malone, if you have a form there, could you fill that in and have her sign it, please? We're going to have you sign a form that's entitled Waiver of Counsel. And basically what it says is that you being aware of all of your rights here in open court and are voluntarily waiving your right to counsel. If you sign that, we'll put it in the file so that will show in the file documentation that you waived your right to counsel.
She has signed it, sir.
All right, thank you. You would just send that up then after the hearing. All right, so Ms. Knisley, the allegation alleged that on or after April 29th of 25, you failed to report to Highland County Probation Department after you failed to report to Clean Acres pursuant to their recommendation. And then Rule 13 is on or after 429, okay, Rule 13. So it's basically the same act, but it's alleged to be violations of both Rule 2 and Rule 13. Now, you understand the allegations against you? All right. Now, if you admit to the allegations, you're admitting the allegations are true and that you have violated your community control as charged. If you deny it, it means that you're wanting to have a hearing to argue either that you didn't violate one or more of the allegations. And in that hearing, you're entitled to cross-examine the witnesses the state presents, ask them questions to try to help your side of the case. You're entitled to present evidence on your own behalf. And the burden will be on the state to prove that you did violate these conditions. You understand that?
Yes.
All right. Do you have any questions about the allegations?
No, sir.
All right. Then do you admit or deny the allegation in the notification?
I admit.
All right. So I see also that the drug court coordinator, Tanya Sturgill, is also present for this hearing by Zoom. So what's the recommendation of the probation department regarding disposition of the case?
Your Honor, we all know that Ms. Knisley has had her fair share of struggles. She did have quite a period of sobriety. We're all very proud of her. She did have some lapse in judgment, which led to a relapse. So the dates, the case was actually ordered on May 1st. She did show back up at ACM on May 11th. There was a time of detox and stabilization, and then, of course, transportation. And as you know, you were out, and as was myself and Johnny Kim were all out last week. So we did arrange to have her brought in today, but we had her, she was accounted for as of May 11th. So she wasn't out on the run too long before she did come to her senses and get back into treatment. We are recommending that she be given this one very last chance. We absolutely will not be asking for another chance, but we would like to see her be able to continue at ACM and try to turn this around.
So, Ms. Knisley, what would you like to say regarding this?
I would just like to say that I never say this, but I am honestly so sorry for just disrespecting the court. And not only that, but I threw away 14 months of sobriety, and I don't think that was crushing to me. And I reached out to my support, and I asked for help. They took me back to ACM, and immediately I told them I have a warrant. I even looked at Stacy, and they said we would work it out. I just needed to get to a safe place, and I just regret my decisions, and I'm very sorry.
So when was the probation department notified that she was at ACM?
I got to ACM on the 11th, and I don't have my telephone because I agreed with Tim Stacy if I came out and start from scratch at the bottom. So all my telephone communication went through Miss Sam and Natalia, and I believe that they called them the day after I got there.
Okay, actually I was asking Ms. Sturgill, Mr. Parr, so
Sorry.
one of you could answer that.
Yes, sir. They did contact us shortly after that. Again, she needed to be detoxed and stabilized.
And again, what was the date?
I believe it was May 11th, yes.
Okay, all right. All right. Well, Ms. Knisley, what I'm going to do is I'm going to continue on your community control. with a couple of additions. First of all, I'm going to extend your period of time, if I haven't already, to 5 years because, this is quite a setback for you. And the thing that's, the most concerning to the court is the fact that, you took it upon yourself to make your own decisions regarding what you think is in your best interest. And as we explained to you, and I try to explain to people, is that, you don't get to make those decisions on your own because your independent decision-making is what puts you where you are now. And in the past, it's put you in prison, and you had a very extensive record. When you're left to your own devices to make your own decision, they suck. It's just, let's just put it bluntly, they suck. You need to listen to them. So I'm going to give you one more chance, and this isn't going to be your last chance. And because you've had a previous conviction for burglary, you are found to, if you get violated and terminated from the drug court docket, you can be sentenced to prison and do your time in prison. And you can do up to 24 months, less any credits you've got for STAR and, any jail time. But you need to comply with the conditions. That's in the orders. It needs to be done. And, the one good thing you did do is you did go back to treatment, but you did it about 10 days, 12 days later. We didn't have any, she had to detox, so she'd been using, right?
I relapsed.
I wasn't asking you, I was asking Miss Sturgill. Was it reported to you that she detoxed, or? You're muted.
Yes, she had relapsed.
Okay. So, you went out and you relapsed, and then you came back. At least you did that. But, it's one thing for people drug court to relapse or community control to relapse. But it's another thing for them to leave and go out on their own and then relapse. That's because, your refusal to comply with the rules is what led to your relapse, not your drug. Your drug addiction certainly is a problem. But if you've been in compliance, if you've done what they told you, you'd have gone into treatment immediately. You wouldn't have come out in, another 10 days of using, which you probably used every day, because most people do. But whether it's every day or every other day, doesn't really matter. If you tested positive, I'm sure you were using. So I'm just to tell you, this is your last chance. So you're to complete your treatment program. Right now, that's ACM. If you that's not to be changed unless it's approved by your treatment team, and then you'll have to pay the additional cost. So did they hold a bed for her so she can go back there today? Okay, so you'll be able to be released today to be transported back to the facility. All right, you have any questions, Ms. Nicely? All right, we need to understand this is it. No more excuses. It's time for you to make your decision on your life, whether you're going to get clean or whether you're going to continue to use and go back to prison, and that'll be up to you. All right, thank you. We'll bring in Mr. Bond, please. All right, are you Jason Bond? All right, this is a hearing being conducted by Zoom. Mr. Bond, in case number 24-CR54, it's styled State of Ohio versus Jason Lee Bond, and also 24-CR100. Now, the 24-CR100 is a new indictment for failure to appear, but on the previous case, he was charged with 2 counts of grand theft of a motor vehicle. So we're going to do the notification as well, or going to set up a schedule in both cases. And Mr. King is present on behalf of the state. Assistant Prosecutor William Armentrout is present on behalf of the defendant. Mr. King has the alleged victims of the offenses in 24-CR54 been notified of the time, place, purpose of this hearing, the right to be heard?
Yes, Your Honor. The alleged victim in count 2 has been notified and was elected not to attend. We attempted to make contact with the alleged victim in count 1 without success.
All right. All right. So I'll go ahead then and do the arraignment then. Mr. Armentrout, I'm sure you've been made aware of this indictment. Probably haven't had a chance to do much review of it.
Since this morning, I've not had a chance to speak to Jason yet.
All right. Well, the defendant was indicted on July 2nd of 2024 for failure to appear in case number 24 CR 54, the case that was pending at that time, on or about June 20th, 24, fourth-degree felony. You wish to have an indictment read, Mr. Armentrout?
We'll waive that, Your Honor. I don't know that he's had it for more than 24 hours.
I don't think he has.
I'm sorry?
I don't think he has.
I would certainly recommend that we waive the 24-hour period, but I've not had a chance to speak to him about that.
All right, Mr. Bond, your attorney, Mr. Armentrout, is present here in the courtroom. I guess I forgot to make that clear. But under the law, you have a right to wait 24 hours after you receive an indictment before you're required to enter a plea. When did you get your indictment in the new case?
I believe it was yesterday. Or no, I'm sorry, it was Friday.
Friday? All right, so you have had it more than 24 hours. All right. All right, then, Mr. Bond filled out a financial affidavit. Is everything on this matter, on this case, correct, on this form correct, Mr. Bond?
Yes, sir.
All right. All right, then the court will appoint Mr. Armentrout to represent you in the new case. And how does he plead, Mr. Armentrout?
Not guilty, Your Honor.
All right. All right. At this point, I'm going to set both cases for trial on the same day, the same schedule. So we'll set. Had we had a first pre? Was that the first pre-trial in the case?
We had a first pre-trial, it looks like.
Okay.
Actually, maybe we did. Maybe he's never appeared.
All right. Well, I'm going to go ahead and just do two pre-trials. So we'll do the first pre-trial on June the 25th at 1 p.m. Final pre-trial will be July the 2nd at 1 p.m. And the trial will be set for July 21 in both cases at 8 a.m. All right. Now, the state wished to be heard on the matter of bond in each case.
Yes, Your Honor. The state is requesting that bond be set, $15,000 in each case. I would note that this defendant has had a warrant now for nearly a year. In the 24 CR 54 case, he failed to appear. It looks like from my notes on two separate occasions, and even going all the way back to the arraignment in that case, he arrived an hour late to the arraignment. So I don't think I think the likelihood of him showing up if he's out on bond is slim to none. So the state would ask that bond be set at $15,000 in each case. Thank you.
All right, Mr. Armentrout.
Your Honor, I don't think I can with a straight face ask the court to release him on his own recognizance. One of the new charges is a failure to appear. I have had a chance to speak with his parent who's in the courtroom. He would be able to live with her, and I have not been able to verify this. She indicates that on his own during this past year, entered into and completed a rehab program. They thought in Portsmouth somewhere, and completed that, but it doesn't appear that he left rehab and immediately turned himself in. They believe that he did turn himself into Ross County because he had some issues there. May have been brought here from Ross County, but that's by way of information for the court. But he does have a place to live, and it appears that all these instances were as a result of drug addiction. We just ask the court to take that into consideration.
All right, in case number 24, CR 54, the court will set bond amount of $20,000 plus the same conditions as previously ordered, plus the $171 deposit prior to release. In case number 24, CR 100, the failure to appear case, the court will set bond amount of $20,000 plus OR and the deposit of the $171. The OR bond is your promise to appear, Mr. Bond, and as you've learned, if it's alleged you fail to appear, you can get a new indictment, a new felony penalties possible. You'll also be under house arrest in both cases. If you do make bond, you report to the probation department immediately upon your release. Report once a week for 4 weeks. After that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, and employer. If recommended by probation, it will be evaluated for substance abuse and mental health issues and as treatment indicated. You're enrolled in and follow that during the period of the action. You'll be under house arrest if you do make bond at the address of your aunt, which is 823 Wall Road. Is that correct? All right, in Greenfield. Meaning you'll have to be there at all times unless you're working, going to and from work. Medical appointments, which includes treatment for substance use disorder. Court proceedings in this or any other case. Appointments with an attorney or probation officer in this or any other case. May also attend any kind of job training, educational programming, schooling, etc., or church services. Other than that, you have to be there at all times. If you fail to comply, that bond can be revoked and you'll be held till further order of the court. Are you also facing felony charges in Ross County?
I'm done with everything.
All right, just misdemeanors then when they picked you up, apparently? Okay.
Yeah, it's done. I'm done.
Okay. All right. I just want to make sure. All right. Anything further, counsel?
There you go.
All right. Thank you.